Hello, I'm Justin M. Kennedy, an attorney with Litherland, Kennedy & Associates, a California estate planning and elder care law firm. Today I'm going to discuss California's Proposition 58. Proposition 58 is a California constitutional amendment approved by the voters, which excludes from reassessment transfers of real property between parents and children that has been effective since November 6, 1986. Proposition 58 is codified by Section 63.1 of the Revenue and Taxation Code. Proposition 58 allows the new property owners to avoid property tax increases when acquiring property from their parents or children. The new owner's taxes are calculated on the Proposition 13 assessed value instead of the fair market value when the property is acquired. The following types of transfers of real property are excluded from reassessment because of Proposition 58. The transfer of the principal residence, and there is no value limit on the home. The transfer of the first $1 million of real property other than the primary residence. For calculating the $1 million of other property, you need to look to the assessed value, not the fair market value. The $1 million exclusion for other property applies to each transferor. Therefore, one parent can transfer $1 million of other property, and the other parent can also transfer $1 million of other property for a total combined exclusion of $2 million. Please note that these transfers are coordinated statewide and are added together to determine if you have exceeded the $1 million limit. Let's make sure that we understand who qualifies as a child under Proposition 58. Child and/or children includes the following: sons and daughters, sons-in-laws and daughters-in-law, stepchildren, and children adopted under the age of 18. The parent-child transfer exclusion is not automatic. You need to file a BOE 58 form with the county assessor to claim the exclusion. The form is considered timely filed if it is filed within 3 years after the date of purchase or transfer. If the transfer is due to a death, the date of the transfer is the date of the decedent's death, even if the property is not transferred until a later date. What if you do not file the BOE 58 form within the 3-year time period? Then the assessor will only grant the exclusion as of the year in which you filed the return. The prior years between the transfer date and the filed form being approved will result in the property being reassessed for property tax purposes for that period of time and will revert back to the assessed value, taken into consideration Prop 13, for the year that the form was filed and thereafter. What about if the property was held in a living trust? Is it still eligible for the Proposition 58 exclusion? Yes, the county looks right through the revocable living trust. The county may request a copy of the trust to make this determination. What about if the property was held in a family partnership or an LLC, a limited liability company, or other legal entities such as partnerships or corporations? Then no, the Proposition 58 exclusion would not apply, as the transfer must be from an eligible parent or child and may not be made from legal entities.